In a contested divorce case in New York, when and how does discovery begin?
Discovery, in theory, could happen even before the preliminary conference. Oftentimes, the parties will exchange net worth statements. Indeed, usually that even kicks off the settlement negotiation. For instance, unless my client says, I am very confident I know what the other side has, maybe they've filled out joint tax returns, they know what assets the other side has, and they're willing to waive in writing their ability to get a net worth statement. Usually the net worth statement is a preliminary to settlement negotiation. And sometimes even before the preliminary conference, just to aid settlement negotiation, if there's specific issues that the other side wants clarified. For instance, maybe there's one party or the other is requesting a premarital credit. Let's say they took money that they had before they got married and they put it towards the down payment on the house or the co-op or the condo. Oftentimes they'll then need to get the documentation which will show both ends of it. So in other words, they have to show where the money came from in the first place. And then they also have to prove that that same money was put down at the closing. So a lot of times I'll tell my client, they'll need to get the closing statement so that we can see what checks were actually exchanged at the closing. And then get the bank account statement so that we can see where that check was drawn from and see that it was drawn from premarital sources. But there might be other issues. For instance, if somebody had a retirement account going into the marriage, generally retirement is exchanged based on a formula that states each party will get the value that accrued between date of marriage and date of commencement of the divorce case. And so, if somebody had a retirement account going into the marriage, they have to prove what was in there as of date of marriage. So they'll need to retrieve the statement from that. I've had other exchanges of disclosure before the preliminary conference. If somebody says, well, I think the other side was taking money out of their bank account and sending it off someplace, or just recklessly spending it. And, maybe there's a few months or a year or so of bank account statements that are exchanged, just to kind of address those issues. But then in the preliminary conference order itself, one will see that the mandatory disclosure is considered 3 years worth of financials. And when we say that, we mean 3 years worth of bank account, that's checking and savings account statements, 3 years of credit card statements, 3 years of investment account statements, and 3 years of retirement account statements. That's considered mandatory. The parties often, though not always, but they often ask for more documentation than just the mandatory disclosure. And that's captured in a document called a demand for discovery and inspection. It's just a long way of saying I want certain documents to be produced. And so each side will come up with a list of documents that they want produced. Oftentimes there's about 20 to 30 different categories of documents that are exchanged. If either side thinks that the other is abusing that, asking for too much or asking for irrelevant documentation, key thing is they have 20 days to object. If they miss that 20-day deadline, they pretty much have to answer it whether they like it or not. So if you get a demand for disclosure or demand for discovery and inspection in from your attorney that the other side has asked for you to produce documents and you don't agree to producing one or more of those categories of documents, you have to contact your attorney ASAP, because again, your attorney has that 20-day window to object, and if they miss that window, you may have to produce those documents, like I said, whether you like it or not. The other typical demand is called a demand for interrogatories, and that's simply put a list of questions that you have to answer under oath. In New York State, generally speaking, with rare exceptions, the court will limit the attorneys to 25 questions. So if you get in 26, you need to let your attorney know, hey, I need to object to one or more of those questions. And they can just write the other side a letter and just say, hey, parse the questions down to 25 or less. Otherwise, we're going to choose which 25 questions we answer. And so other typical documents are demands for expert witness disclosure, a list of witnesses that the other side is going to produce at trial, and then also demand for items like audio and the video evidence, picture evidence, any other type of evidence that's going to be introduced at trial, including but not limited to the other side's statements, whether they're oral or written statements, so that there are conceitedly no surprises at trial. That's the purpose of disclosure, so that you don't get to a trial and the other side starts whipping out documents or videos or audio clips that you've never seen before. So those are the typical demands for disclosure done in a contested divorce case.